Before we hand it over to Cory Foley, I wanted to introduce him to you all. He wrote the Yoga Law book and is the founder of Conscious Counsel. He has served hundreds of clients in the health and fitness yoga space all across the world, the majority of whom own or operate a fitness health studio. He has presented at conferences around the world, teaching about the law in a fun and practical way. And yoga is supposed to be fun, right, Cory?
Yes, as is law.
Yeah, so with that, if you have any questions, add them to the chat. We will make sure or try our best to answer them live. But if we all are ready, Cory, you can take it away.
Cool. Thank you so much, Lizzie. And I would be remiss to do anything beYogi related and not give a shout out to Big Joe, who was like, Joe Fagan was the first point of contact I had at beYogi, and this is the first time I've done anything beYogi related without him being here. So what's up, Joe? Yeah, we're like, love him, love that guy. So, but Lizzie, I have to say you're doing a fantastic, wonderful job.
Thank you.
And I've already forgotten about Joe, to be honest, even though, yeah. So my name's Cory. I'm a lawyer. I work specifically with yoga professionals. I have a law firm that's called Conscious Counsel, and we work mostly with yoga professionals and yoga studio owners. And so the whole point of this call always whenever I'm on with beYogi is basically for me to share as much legal information as possible. The best way for all of us to maximize this time, if you have any question about the law and yoga, please go ahead and put something in the chat and ask a question. I think Lizzie will have a look and she'll be able to monitor it. On a daily basis, I'm probably, speaking to between 5 to 10 clients a day, understanding a little bit about what they're going through and what issues they have. And the first thing I want everyone to know when we're talking about the law and yoga and being a yoga professional is that, like, I can promise you that whatever legal questions or issue you're going through right now, it's something that me and my team have already been through. So I say that, so like, it's a super safe space. Whatever questions you've got, let me know. There's no, all questions are welcome. All I want to do is to be able to help. And the more and more that I have conversations with different yoga professionals, the more I see the need for us to understand what's going on with the law in our business, but also to feel empowered by it. And the reason why we make law fun at Conscious Counsel is because it's law and accounting are two aspects of your business that you're inevitably going to have to deal with. So we might as well, get excited about it, feel empowered by it, and look forward to learning about it. Does that sound cool? Everyone just give me a thumbs up if you, I can't actually see if anyone's giving us thumbs up. So I'm just going to assume that thumbs up are being given. Lizzie, can you give me a thumbs up?
I can give you a thumbs up. Here
okay, cool. Wicked. So before I dive into some of the specifics that I'm going to talk about what's happening in the industry now, we have a checklist, a legal checklist that we come up with at Conscious Counsel. And the reason why we've come up with this free checklist is that often before we work with any yoga professionals, they'll say like, oh, I don't know what I don't know. What should I have in place? Do I need this? So Lizzie, if you don't mind just to post a link to that free checklist and you can download it. And the benefit of that is it's a starting point. It's sort of like you have a map of where we're going to get to best legal practices. And it's our pleasure to share that. As well, I wrote a book called the Yoga Law Book, which I can put a link at the end of this and share it. And I basically wrote that book having gone through a lot of journeys with yoga clients and seeing everyone sort of make the same mistakes. And I was like, hey, why doesn't someone write a book about it so that we can, illustrate legal principles and do so in a fun way. So all of that aside, I'm happy to sort of dig into where we are and what's going on in the world and what's going on with law and what's going on with yoga. And just a reminder, if anyone has any questions or anything, just throw it in the chat and I'll really look forward to getting to it. So what we're seeing happening now is that we see a lot of yoga professionals preparing to reopen. And when we say reopen, it's like the way how this whole thing has progressed is that, life was normal. We were doing what we normally did. And then everyone went to just perform, offering things online. And then like we could sort of open at 10% capacity or 25% capacity. But now, and then we were shut again. So we were back online. And now we're at this point where as spring is, spring is springing and we're getting ready to operate in person again. I see a lot of clients coming in with questions where they're like, how do I have a game plan around that? How can I make sure that my legal documents will cover me for, the different ways that I want to provide services? Randomly, like more than ever, I have yoga and Pilates professionals who are telling me that they're either going to their clients' homes or they're offering services in their homes that they're themselves right now. And that's just an example of something that like 6 months ago, we didn't really hear that, but now that's something that's coming on. So I want to make sure that all of us are covered for that. So that's where we are. Where are we? We're getting ready to reopen. More and more people are becoming vaccinated. And also what's entering the mainstream of questions is like, how does it work with this vaccination thing? Like, am I allowed to work only with people who are vaccinated? If so, am I supposed to collect their information? How do I ask them? How do I do things? So I'm here to answer any of those questions and sort of share some of the best practices that we have. The first principle that I just wanted to sort of speak about as we're talking about reopening or even just being at best legal practices is the way that I always encourage my clients to think about the law and working with the law is that you want to have a document that helps you create the ideal working relationship, right? So the whole idea of the document is that, okay, I'm taking you on as a client, or we're working together with you as a client, or if someone's going to be my business partner, or if I'm, leasing a place out, or if I'm hiring a staff, whether they're a contractor or an employee. And the goal is that I want to use a legal document as a means to communicate all of my expectations for that relationship openly and honestly. And the benefit of having a written document is that in the event that something goes wrong, or in the event that you actually need to rely on any agreement that's been drafted, you have something that is executed, that's legally binding, and that clearly, objectively states like, hey, before we started this relationship, this is what we said we were going to do. And now we're in the relationship and you're doing something differently. So how can we correct that? And so because the purpose of legal agreements is to help communicate expectations in a relationship, the reason why we need to revisit our agreements now as we're reopening and things like vaccinations are entering the mainstream, and just as our business is evolving, whether we're offering services outdoors or if we're doing it in personal homes, is that the way that our business operates has changed. The types of relationships we have with either our staff or with our team or with our clients has changed. And so anytime that our relationship is changing, we want to have legal agreements that capture the most recent version of the relationship. So let's say hypothetically, I'm a yoga teacher and I got legal agreements in February 2020. And now I'm still using these agreements today on May 5th. Cinco de Mayo, happy Cinco de Mayo, everyone. Dia de las Muertes. We should have put on makeup, Lizzie. How did we miss that? We should have put on that Mexican makeup and I presume eat in traditional foods and listen to music and danced.
Maybe next time.
Wow. Do we have time for me to go to the makeup cabinet?
No, come on, Cory.
Okay, Lizzie. Okay. I'll keep going. But what I was saying is, okay, so let's say I had legal agreements from February 2020 and now it's May 5th, 2021. Probably everything about my business has changed. The way that I collect payments has changed. The types of payments that I collect have changed, i.e. maybe it used to be a monthly membership. Now it's just a 5 or 10 pack, or it's just a one-off. Obviously the risks of the activity with waivers, and I'll probably start off talking about waivers, has changed. So you just want to think about updating your law as like updating your relationships. And because so many circumstances are changing, naturally, we're going to want to update our agreements. The last sort of precursory, but like all of this is actually really the important stuff. This is really the juice of what I'm going to get into. And as we specifically talk about the law, that's more specifics. But what I want everyone here today leaving with is like a practical understanding of why it's important to have legal documents. And then we're going to go into each area. But this is like, realistically, this is how a legal problem will unfold for you and how it unfolds for my clients. And I've been through this so many times that for me, I always have to remind myself to talk about this process, because for me, it's something that's so normalized and automatic. But for so many yoga professionals, it's not, because they're not yoga lawyers and they haven't been going through this, but it's still really, really helpful information to know. So the way that it goes is the point of these documents is so that you're practicing proactively, right? So I have documents that are tailored for me and my business and that I'm using and that set the terms of my relationship so that if a problem comes up, I'm going to be protected. That's the whole point. How this actually comes into action and how we really actually need to use the agreements will be as follows. Someone is going to have a complaint. Someone's going to be upset about something. Someone's going to be injured. Someone's going to want a refund. Someone's going to want to cancel. Someone's going to be disappointed they did not achieve a result. Like, this happens all the time in every business. The first step they're going to do from a legal perspective is they're going to either send you an email or they're going to hire a lawyer who's going to send you something called a demand letter. And that's them basically complaining. And they're like, hey, you know what? I hit my head when I was doing a yoga class. You were instructing us to do a handstand and then I fell, and now I'm having, concussion-like syndromes, and I can't focus and I can't look at light, and all of these really, really unfortunate things. As a result of this, you are responsible. I've been off work for X number of days. I'm only able to work X number of hours. And then they're just going to come up with some crazy number like $59,000 worth of damages that you're responsible for. Now, the way that it always goes in law, and like, this is the story I share in my book that is really important, is that the principle is called pay me now or pay me later. So if you're going to be operating an online business, at some point you're going to need a lawyer and need legal agreements. And if you're able to be proactive and pay for that upfront, then when an issue comes down further down the line, you don't need to pay later. And this is the principle that I'm going to illustrate. So someone's made a complaint, they've been off work, they're suffering post-concussion syndromes, and then they're going to send you a demand letter. Let's say you pay me now upfront. I understand that there are costs of being a small business owner, and I invested in a waiver. You're going to reply to them, hi, I'm really, really sorry that you're injured. I always prioritize taking care of anyone who practices with me, and I'm really sorry about this. Before we work together, you signed a waiver of liability, which specifically outlined what activities we would do, what the risks of those activities were, how those risks could materialize. You agreed that you were healthy enough and you voluntarily participated. And before I let you practice with me, you agreed to relinquish any legal rights that could be brought against me. Full stop. At that point, all of the momentum is taken away from that person. As unfortunate as the circumstances are, they signed a waiver before working with you. It's properly executed. It's properly drafted. It covers you. There's no problem. Conversely, let's say you don't have that document, or like you have a February 2020 document, or you borrowed your friend's, your cousin also has a studio, so you borrowed their document. If you don't have a waiver of liability that's going to help protect you, the way that situation goes is completely different. Now that situation goes from a one email response, taking a screenshot of the relevant provisions. And then conversely, if you don't have it, it's like, well, we told you it was going to be dangerous, or you signed this waiver, and then the lawyer's going to review the waiver. And I've been that lawyer before. That lawyer is going to review that waiver, and they're going to say, well, actually, here's why it doesn't apply. This is poorly drafted. The party's not named correctly, or the activities weren't specific enough, or whatever it is. And now you're into negotiations and you run the risk of possibly getting sued. And the way that I've used the waiver of liability as one example, but this is really how you want to have all of your relationships in order. So let's look at the contractor employee distinction, right? I've hired a team to work with me and I've classified all of them as contractors. unfortunately, I don't, things have slowed down, so I have to let some of them go. And then someone wants to file a claim against me and say, oh, well, I'm filing for unemployment insurance. And even though you called me a contractor, you treated me like an employee, therefore I'm allowed to file for this insurance. This is like a big headache for you and your business. You run the risk of getting audited by the IRS. So you're going to want, it again comes back to that, like, what is your first response? Is your first response like, oh, well, here's the signed agreement and here's everything in order and here's a copy of you signing it? Or is it, oh, we told you this, we told you that, look at this one email from this date, and scrambling and getting stressed? And like, when you're scrambling and you're getting stressed, all of the focus that you're taking away, all of that focus takes away from you and your business. And like, probably as a yogi, your favorite part of the business is actually, facilitating the services and leading your community. It could be that you love the marketing part. It could be that you love signing on new people. It could be that you love writing blogs or making videos. But I don't want law to come in the way between you loving your business and you growing your business. And so that's why I want to share, like, if you remember anything from this whole video, just remember the importance of having appropriate legal documents. You don't have to sign up with me to get them. I hope that you work with someone who you love working with and someone who understands yoga and the law. But the biggest problem solving that I always am working out for my clients is like someone who didn't have something properly done at the start, and now like reverse engineering all of the challenges, solutions, and like a bill that's way, way higher in order to resolve that. So this is the universe sharing a message with you to like get the legal in order. Let's update the relationships. And I think that's a great segue for me to just quickly address waivers of liability. I saw a couple questions about waivers came in, so I'm just going to like do my 7-minute spiel where I talk about waivers and how they work and why they're important, and then we'll address those questions. Sound cool?
Sounds good.
Okay, Lizzie, give me the thumbs up. So waivers of liability are a document where, I'll take one step back. If no one signs any document, let's say I'm a yoga teacher and I've got a yoga student who comes and practices at my home. Let's say we don't sign anything, we don't agree to anything legally. What the law says is that anyone who's facilitating activities for another person, especially if you're getting paid, even if you're not getting paid, but especially if someone's paying for that service, whoever's facilitating those activities has a responsibility to make sure that that person does not suffer damage or harm as a result of participating in those activities. So before we sign, the law automatically says the teacher's going to be responsible to make sure the student is safe. Now, what can happen is you can get your students to sign a legal agreement, which, if properly drafted according to all the specific technical requirements that I'm going to go over in a second, if the agreement is properly drafted and it's unambiguous and it's very clear, the law says that the student is allowed to sign away their legal rights that they otherwise would have. So a general rule in law is 2 parties can agree to anything so long as it's not illegal. So whatever is going on, but once we sign an agreement, so long as that agreement is not illegal and does not contravene any other laws, the law will say, okay, yes, we accept this particular agreement. So waivers are an area where these agreements are accepted. And the law says, okay, normally the teacher would be responsible to the student, but if you sign this agreement, then the student is allowed to extinguish or relinquish or waive their own rights and release the instructor from liability. This is what we want for you. We want you to have a great waiver so that your students are releasing you from any liability. Now, there are 5 key elements that a waiver of liability must have. And the whole rationale is just so that everyone understands, the reason why courts came up with these documents, they were sort of like, okay, like we will let someone sign away their legal rights, but we take it seriously, so it actually needs to be really, really clearly and properly drafted. That's why waivers are different than everything else. And so in a waiver of liability, you're going to have to describe the activities that you're doing with your clients. So the reason how like the curveballs that come from the industry changing by opening and closing and reopening is that the activities that we're now offering, we're not just offering yoga with equipment and balls and straps and mats and light weights and whatever else we could be using. But we're also offering yoga possibly outdoors in public outdoor spaces. We're offering yoga possibly in our homes or in the homes of our clients. We're possibly offering yoga online or through evergreen video content, or we're offering yoga services in person with the risk of a communicable disease. So I don't want you to be overwhelmed, but just from a legal standpoint, these are the things that we want to make sure are all addressed in the agreement. So not only are we doing yoga, but these are the places that we're doing yoga in, and we want to clarify that. An example of like, a question I always get is, how specific do I have to be in listing the activities? And I'll give you an example. If you do prenatal or postnatal yoga, that is something that should be specifically listed. And I'm just going to answer Joe's question because I quickly see it. Online evergreen. So evergreen content is a term for like a video that you record one time and that people can, if they have a membership to working with you, they access that video, and it's like, it's evergreen because it will always exist there. So if I were to, right, Joe, does that make sense? Evergreen just means that something that someone can always access, and something that's not live. It's pre-recorded material that people can always access. But so I was talking about activities and like, should prenatal and postnatal be included? And the answer is yes, because it's all, when it comes to a waiver of liability, it's all about how specifically it can capture the activities that you do. And normal vinyasa yoga or flow yoga or yoga nidra or yin yoga and prenatal yoga are very, very different activities. And as such, your waiver needs to make sure that it covers you in the event that you're doing both. So the first thing is, what are the activities? The second is, what are the risks of the activities? So this is what we're going to be doing. We're going to be stretching. We're going to be doing body weight movements. We're going to be using light weights. We're going to be using mats and straps. What are the risks of these activities? And then what are the outcomes of those risks? So even if we just look at something like prenatal yoga, the activity is prenatal yoga. The risk is that, you know, someone is pregnant or super pregnant and practicing yoga. So, you know, making sure that everything's done properly. But some of the risks is that, you know, there might be some undesired contact with the body in certain places. And then an outcome of the risk could obviously be something quite serious. And that should be outlined. It's not always fun to put the outcomes of the risks in a legal document, but that's what all of this is about. Like, before you're allowing someone to practice with you, you're saying to them, hey, like, these are the actual risks of participating in this activity. And, you know, I have a perfect track record. No one's gotten injured. I've done prenatal yoga for 17 years, but in the event that, you know, there's some freak accident or something happens, this is a very realistic risk. So it's activities, the risks, and then the outcomes of the risks. Just to also add, like COVID, right? Coming back to practicing in person. There's a communicable disease that's highly contagious going around. That's an additional, you know, the activity is practicing yoga in an environment with a communicable disease. You know, the activity is different, and then the risks obviously of that are different as well. Then once we cover with activities, risks, and then the possible outcomes of the risks, then it's just someone affirming that they're healthy enough to practice, that they fully understand everything they're getting into, and they voluntarily participate. And then finally, they release you of liability. So those are sort of like the 5 major points are, what are the risks? What are the activities? What are the risks? What are the outcomes of the risks? Having been told all of that clearly, someone voluntarily chooses to participate. They affirm that they're healthy enough, and then ultimately they release you from liability. So I'll just sort of pause there, and I'm happy. I hope this is landing and that this makes sense. If anyone has any questions, I'm happy to answer them.
Yeah, we had a few questions come in. So first off, before we get into the nitty-gritty about some of the pieces to the liability waiver, Stacy asks, she's just basically wanting, do you draft waivers for every state in the United States? So she's located in Maryland. So she just wants to know if you are able to draft a waiver for that state.
We do. We work with clients internationally. So we've got clients in Australia, New Zealand, and Singapore, and Italy, and the UK, and parts of Europe. and all over the United States and all of Canada. We draft our agreements according to best legal principles. So when it comes to waivers, like it'll be the most conservative version of a waiver possible. And it does, there are small variances on waivers from a state to state level, but specifically for yoga and Pilates, we draft agreements. We've got clients all over the world.
Awesome. I hope that answers your question, Stacy. Another one came in from Anne. So this is about kind of online waivers. She says, does filling out an online Google form count as a signature when the participants type their full names on the question that says signature?
No, I would say no. And I'll tell you where this comes from. What was the name of the person who asked that question? I'm sorry.
Anne.
Anne. Hey, Anne, what's going on? So the answer is no. And the reason why waivers are different than disclaimers is that, and again, remember how I said waiver, the waiver is the agreement where someone's signing away their legal rights. This is the one that, like, it has to be done properly. Of all of them, the most important is to have the waiver done properly. So someone reading through a waiver and then typing their name in, it's not an ideal form of execution. I can share with you what the best practice is. The best practice is someone receives an agreement at the top that says waiver of liability. We don't include any other type of agreement in the waiver of liability, because remember, this is someone signing away their legal rights, and other forms of agreements are usually people agreeing to something, like I'm signing up, to work with you, to be a client of yours, or to get coaching, or whatever it is. The waiver is someone signing away their legal rights. Before someone can properly execute a waiver, you have to give them an opportunity to read it entirely. And so you'd have to say something like, before signing this agreement, you agree that you've had an opportunity to read it. Here's a copy of the waiver. Then once they go through it, they can click something like, I agree to be legally bound by this waiver. But the best practice that we tell all of our clients is to use something like DocuHub or DocuSign or HelloSign or Waiver King, something along those lines, and actually have people execute a signature line, which would be dated, and here's the signature line, and then it's signed. And again, the reason why, if someone's filling out a Google sheet, it may not be super clear that someone is signing an agreement to sign away their legal rights. And you just want to make sure that that's like super 100% unequivocally clear. And again, as I said, the courts treat these documents different than other documents because this is someone signing away their rights. And like we know in the Western world, our rights are a fundamental freedom. So before we're going to allow someone to do that, the courts are like, this really, really has to be done properly. And so for me, I've been hired to challenge waivers of liability in the past. And if my client just typed their name in a Google form that, wasn't so clearly lined out, that's the first thing that I would challenge. And like a waiver of using someone else's waiver or a waiver of liability that sort of doesn't work, it's sort of like a broken seatbelt. Like, yeah, you can be using a broken seatbelt, but when you actually need it, what's going to matter is that it works for you. And I hope that answers your question.
Yeah, that was great. Thank you. So another one about waivers and kind of in the online scape. So Heather asks, how would a waiver work if you teach only via Zoom and then also pre-recorded YouTube videos? I think they're potentially different. So can you explain that?
Yeah, sure. So if you're only teaching online, your waiver could specifically outline that. And like some things that you'd want the waiver to address for online practice would be like, someone making sure that the space is safe enough. So saying, hey, you're the one who's going to be monitoring your space, make sure that it's safe enough for you. And also like making sure people don't push themselves too hard, having some language around that, because obviously the difference between practicing on Zoom is that you may have a class of 7 people and you can't give everyone that attention, where if you were walking around a room, you would be able to. So you just want to make sure that if you're practicing online, the waiver covers you for all of those related online activities, risks, outcomes. And then when it comes to pre-recorded YouTube materials, YouTube, the best, sort of the best form of protection that you can have for YouTube is a disclaimer. And what a waiver, the difference between a waiver and a disclaimer is, a waiver is like a document that someone signs, which is them agreeing to sign away their legal rights. Whereas a disclaimer is, it's more unilateral. So you use, if this is the analogy I always give, it used to be like there was a yoga studio and people would come sign in at the front desk before you'd allow them into classes. That's when they sign the waiver of liability. So you're able to control who is coming in and what, that they're signing everything. You're involved, you're allowing everyone to enter. The equivalent on May 5th, 2021 is like giving people a Zoom link to participate in class. If you have their email address, they should be signing a waiver of liability. When you do something on YouTube, it's like, it's up there and you can't control everyone who's viewing it. So the best thing that you can do is have something like a YouTube disclaimer that you would include in the description of the video. Like, hey, you do this at your own risk. These are our qualifications. This is how many hours we've done of training. Don't push your body too hard. If you're not, consult with a doctor before doing it, all of those things. And that's sort of the best form of protection that you really can get for doing things on YouTube. And I hope that helps.
Yeah, that was great. Thank you. So I know we have a good bit of information left to kind of speak on in this training and webinar. So if we did not answer your question specifically about waivers, potentially we can get to it at the end. But Conscious Counsel and Cory have offered a free legal consultation. Kate at beYogi will be adding that link in there for you guys to sign up. But we also have a free checklist written by Cory and Conscious Counsel. So take a look at that as well. But Cory, we can kind of continue with this and answer any waiver questions at the end if we have time.
Cool, awesome. Let's keep rolling. So I know one of the big questions that was coming up are about vaccines and what our rights are under vaccines. And it's obviously it's a bit of a polarizing question, and it's also relatively new because now this is coming into it's coming into the mainstream of our society with a higher percentage of the population being vaccinated. Now business owners are starting to think like, okay, well, what am I allowed to do? What can I do? What should I do? And the first thing, like, to answer what should I do around, and I'll give you an example of where this plays in. You could be a yoga studio owner and you could say something along the lines of, I want all of my staff to be vaccinated. Otherwise, I don't want to work with them. I'm not interested to work with them anymore. Additionally, you could say something like, I will only be working with I'll only be working with students who've received a vaccination after a certain, amount of period after they've gotten the second vaccination or whatever it is, right? And so like this is coming up, and what we saw happening in the month of April was a lot of yogis were reaching out to us saying, I want to put something in my agreement around vaccinations. And it could be I've spoken with so many different clients about this on both ends of the spectrum that like some people are saying, I don't care at all if anyone's been vaccinated. I don't want to talk about it. I don't want to address it. I'm whatever my position is. And I have other clients who are like, no, for sure. It's super important. I won't deal with anyone who hasn't been. Obviously for me, I have zero preference as a lawyer and as a law firm. We work with our clients and we help them we help them draft documents that achieve what it is that they want to achieve. So I have zero position on what the right thing to do. What I will say, the same thing with every other aspect of your business. If you're the business owner, you should be doing what feels right to you, and that you don't feel, you want to make sure that any decision that you're making comes from the top down, and that you feel good inside with the decision that you're making. Your decision could be, I'm not even going to address vaccinations at all. Your decision could be different. But the most important thing is like, I'll get questions from clients like, oh, what should I do? And I was like, you have to determine what you think is right for you. When it comes to legal implications of the vaccination, I just want to share a couple of things. And like one of the biggest misconceptions that we've been dealing with is people feeling that they're afraid that they'll be discriminating against someone if they're excluding them by virtue of not getting a vaccine. And it really is not an issue that touches on discrimination. Discrimination would be like allowing or disallowing someone to do or not do something based on their age, their gender, their religion, their race, their creed, their color, whatever, anything like that. That would trigger, someone to have a right to say that they were discriminated against. What this falls under is public health. And the question around vaccinations is not whether or not we think vaccinations is right or wrong, but the underlying public health interest of someone being vaccinated or not. And the reality that someone who, I don't read the scientific reports, but it's generally accepted that someone who has received a vaccination is less of a health risk to those people around them. So the analogy that we've been using at Conscious Counsel has been like, the way that we want our clients to think about this is, it's the same if like someone doesn't want to wear a shirt or doesn't want to wear shoes. Not strangely, but like I normally don't wear a shirt or wear shoes. But that's just because I live at the beach. But it's funny for me that like now as a lawyer, this is what I talk about. But like if you think about you being a restaurant, or if you're a restaurant, you're allowed to refuse entry to someone if they're not wearing a shirt or if they're not wearing shoes, because there's a public health concern that's involved with that. So you're allowed to say to someone, I'm sorry, if you're not wearing shoes, you're not wearing a shirt, we're not going to permit you to participate in the activities that we're offering or sitting and eating here. And this is how we have to think about the whole vaccination standpoint as well, where there is a logical line of reasoning to say, if you have not participated, if you've not received a vaccination, we will not allow you to participate with us because of the greater health concern happening at our studio. And legally, you are allowed to do that. So you definitely can say to your clients, hey, at this point, I'm only working with people who are vaccinated. The next question is, how do you go about and collect that, how do you make sure you have that information, that you have all of it correctly? And what I will say is that this is much, much trickier, because if you're collecting and storing people's personal information around vaccines or medical information, that triggers a whole other set of different laws that are going to be much more challenging and have a lot of red tape and rules around it. Like there's a lot of Hipaa rules and Hipaa laws around collecting medical information from people. So what we've been doing as a law firm is putting into agreements like different affirmations, or promises or representations, where our clients are not actually collecting that information and holding that information, but they're getting someone to make a representation or a guarantee that they have, by a particular date or for a certain period of time, they've been vaccinated. And that's really like, that's basically the crux of the issue that we've seen. And I'm open to trying to answer any questions about that. But just to summarize the position around vaccines is that, one, it's a public health concern. And because there are other areas of public health concern where you can enforce rules or you can turn people away if they've done or not done something, it's the same would apply here. So long as whoever, like if someone is in a jurisdiction where they've not had reasonable access to a vaccine, that could be a little bit trickier, and you might want to wait for people to have access before you enforce these rules. So I'll see if there's any questions, Lizzie, and I'll pause there.
No, not a lot of specific questions about this. We did have one she just wanted a little bit more clarification about Hipaa. Again, question from Stacy. She goes, can you clarify how exactly Hipaa would apply to a yoga studio or a yoga instructor who collects information on vaccines?
Hipaa traditionally applies to people who work in the medical profession and collect information. So Hipaa's not, what I'm going to say is that as long as you're not collecting information, Hipaa will not apply. But and we're actually, we're putting a blog post out about this on our website, and we're going to include it on a newsletter in the next 48 hours, because we just had someone on our team draft this up. But what my general recommendation for the moment would be is like, do not collect, maintain, and hold medical information from your clients. Just full stop. Just find a way to make it happen without doing that. And there are a lot of ways that you're able to do that. It's not necessary.
Mm-hmm. Yeah, and then another question, it's along the lines with waivers, but I think it applies a little bit with reopening and vaccines and things. Would you be renewing your waiver or updating your waiver in this instance about vaccines?
Not necessarily. I think that the vaccine question doesn't really come in around waivers. My puppy just walked in, so I'm gonna.
Hello.
She just got she's got her puppy shots. Her name is Lua, which means moon.
Oh, she's gorgeous.
She's one of us. She's part of the family now. So to answer the question, the waiver would not have to be a waiver is updated when you're offering new activities or doing new things, and there are new risks as a result of those new activities. When it comes to the vaccines, we see those being part of the membership agreements or the service agreements, and I think that's the next thing that I'll briefly chat about, because it's not really about activities and risks as much as it's about like letting people know whether or not they can participate and what rules are surround that participation. So I think that's a great segue, and I'll just go into it, Lizzie, if that's cool.
Yep.
So at Conscious Counsel, we have two types of agreements for yoga professionals and their students. We either call it a service agreement, which is like anyone who is engaging you for your services. So if you teach yoga, or if you've got a bigger platform, we call it a membership agreement. And if you remember what I said at the start about all of this, as our relationships change and the way that we offer our services is changing, we need to make sure that our agreements catch up and address all of those things as well. So one of the things, so basically a service agreement is the opportunity, and I'm just going to use service agreement when I'm talking about either for your memberships or for your clients, if they're one-on-one. This is the agreement where you create the relationship with your client. So you're going to want to deal with things like payments and refunds and scheduling and cancellations and no guarantees and vaccines and all of these issues. And so what the big areas where we've seen this changing, or what changes we've seen taking place, is that we see a lot more clients adopting a hybrid model of offering, if they have a studio or a physical space, offering services in person, but also online. We've seen them wanting to use these agreements to address things like, wait list or reservations if there's limited amount of numbers. But also we've seen clients want to be proactive in addressing what happens, what happens in the event that there's some, foreseen or unforeseen medical issue which takes place. And here's the process, here's the protocol. And the reason why it's important to have all of these is one thing, it's letting people know what they're getting into before they sign up. So if you've got a clearly drafted service agreement that says, in the event of A, this is exactly what we're going to do. In the event of B, this is what we're going to do. If we're shut down, everything's going to be online. If we're online, we're going to have X number of classes, whatever it is that you want. The benefit of that is that when these things happen, because what I've observed is unpredictability is the only predictable thing for yoga professionals now. It's just it seems like we're always pivoting, we're always changing, we're coming up with new ideas of how we can do things on the fly. You want your agreements to make sure that they capture all of that. As well, we did have, now there's less of them, but we did have some issues with clients who had agreements that only specified in-person services, who then switched to online. In the event someone wants to challenge a payment, they would be able to challenge the agreement and be like, well, the agreement only says that these services are provided in person, and these have actually, they haven't been provided because they've only been done online. Therefore, I want a refund for X number of whatever. And starting a problem. And remember the first things that I spoke about, the point of all of this is to be proactive and make sure that you're in control of the situation more than anyone or anything else. And then again, when it comes to service agreements, this is where we've seen things around vaccination provisions, and people making representations or promises that they've been vaccinated, or if they've not, that they're not able to participate. One thing that's really, really important in terms of like the chronology and the timing of how it works, if someone has already paid for your services, like they're on a monthly membership fee, and you've already collected payment for May, and then you're on May 7th, you want to implement that only people who have received vaccinations are able to practice, but someone who has already paid for the month, has not been vaccinated, but when they paid, you didn't express that to them, you're going to have to give that person a refund. That's just something to be aware of too, that we saw some clients going through. So it's always, the process always for legal agreements, especially in service agreements, is like, before you accept the money, someone signs the waiver. Before you accept the money, someone signs the membership agreement or the service agreement. They execute the agreement, you have a copy of it, and then you accept the payment, so that it's like, hey, we told you everything before you signed up. You read it, you read what type of relationship we're going to have, and then you continue to sign up. So therefore you are bound to all of these terms. And I'll just open up and see if there's anything around that, Lizzie.
Yeah, thank you. Let me look at the chat. Anything, a lot of questions still about waivers, but anything about specifically to these? I did have a question about offering free classes and things like that. So an anonymous said, I teach a lot of senior communities. The individual students do not pay me, nor do they sign a waiver. The community pays me. Should I have some kind of waiver that the activity director of the community signs?
Yeah, I did. Look, the way that the answer is that even if you're providing services for free, you still have you are still legally liable, right? So you're still responsible for someone's well-being, and especially if they're in maybe a more at-risk category, like working with elderly yoga students, that there's a possibility that something can go wrong. Even though they're not paying you, you're still at risk. In the event that there's a third party, like a community center facilitates the yoga, the community center pays you, the senior students will pay the community center, you still want everyone signing a waiver of liability, or you're going to want the community center to provide something for you that's called an indemnity provision or an indemnity agreement, which basically means that the community center accepts all legal responsibility for you facilitating the activities. But I would make sure that that's taken care of in writing.
Gotcha. Yeah. And this also is a good place to talk about insurance, not a lot, but very important in this situation. In case something along the lines, you're continuing to offer these free classes, you're not able to get that liability waiver just yet. Having insurance is super important. So just wanted to add that in there.
Insurance is everything. Insurance is like, it's the seatbelt and the car door and the airbag. Like the insurance is absolutely pivotal, and yoga and insurance go together like almond butter and jelly. Yeah, I just said almond butter. Which reminds me, if everyone can just go into the chat, I've been drinking my green tea and we've only got 9 minutes left, but can everyone just share, like, if you've enjoyed a snack during the course of this webinar, can you just share what that snack is? I've been on my yerba mate, just because like I'm a big snack guy, and like that gets me excited about life. So if I'm talking about law for 50 minutes, I sort of just like need to know that someone was eating something tasty, and then I feel better. Mochi waffles.
That sounds delicious. Unfortunately, I have no snack with me. Just
no, you got, yeah. Well, Joe always had coffee. Joe, not that we have to talk about how things used to be, because things are better now, Lizzie. Today's the best day in the history of the world. But I'm glad I'm seeing a lot of delicious things. So that makes me really happy. What I'm going to do is we've got 8 minutes left. So just one thing, and I believe the link to book a consultation call was put in there. What I want to stress is, like, if listening to this resonated with you, if it seems like you want to get legal documents in place, that you're ready to sort of like level up the law for your business, book a call with me. I'm not able to give legal advice on the call, so I can't be like, hey, the answer is this. But it's more of an idea to speak with serious candidates who want to get packages of legal documents in place and come up with a game plan that we can execute, and we do all of it for you. We make it super easy for you. So I just wanted to mention that. I'm going to talk about trademarks for 3 minutes, and then I'm going to answer any other questions that we might have about waivers of liability, and see if and see what else we have. Stacy her snack has been sampling the joy of a legal discussion in yoga. Wow. Stacy Taylor, you're the winner. That's like, it is joyful, isn't it? Cheers to you. Okay, trademarks, why do they matter? Trademarks are a really, really important building block in helping to secure and professionalize your business. They're also like, if there was a panacea for peace of mind as you grow your business, it would be a trademark. So I'm briefly going to share a trademark is when you register either a word or a logo or a series of words that the general public uses to recognize the goods and the services that you provide. So Conscious Counsel has a registered trademark for offering legal services, for drafting agreements, and for just making law super fun. Now, there are 2 benefits to having a trademark, and one of these 2 will probably touch on you and your business. One is that when you register a trademark, you have enforceable rights and you have exclusive use. That means, right? So let's say beYogi is trademarked, and I'm sure it is. So beYogi, because they have a registered trademark, they are the only ones who are allowed to use beYogi in the context of insurance and selling insurance services and providing, marketing services around insurance. So they're the only ones who use that. If there's another company that wants to come out called beYogi and do the same thing, because they've got a registered trademark, they're able to enforce their particular rights. And they're able to say, hey, the world realizes that when beYogi is being used to sell insurance, it's in connection with our company and our services. Here's our trademark registration. This is why it matters. In addition to the exclusive use and you being able to enforce your rights on others, when you register a trademark, it also means that you have the peace of mind to know that no one else is allowed to register your mark and stop you from using it. So the example would be, let's say beYogi did not register a trademark. And then there's someone in their basement in North Carolina who just decides like, oh, I'm going to register a trademark beYogi for insurance purposes. And even though I haven't used it yet, whatever. If that person goes ahead and registers and gets far along enough in the process to have a sort of, to have a registered mark, they could then go to beYogi and say, hey, beYogi, I've actually registered this trademark and I have better priority because I've made my application that's been approved for the use of this. As such, you have to stop using the name beYogi. And that's what I see some clients coming up with as well. So the dual benefits of registering a trademark is like, one, you can stop someone else from using your name or your business name or for your logo. And number 2 is that you have the ability to, you have the peace of mind to know that no one else is allowed to go to you and say, hey, you're not actually allowed to use this because I registered this. And I've dealt with a lot of things around trademarks in my time. And I see the benefits of both. And I just share this because I had a conversation with a new client recently who was like, well, I'm not going to grow my business and make it super massive. So I don't think a trademark makes sense. But I was like, well, it does make sense still because you want to register this so that someone else doesn't. And when you prevent someone else from registering it, it gives you the peace of mind that you can grow instead of 18 months down the road, you've got a lot of momentum, the business is booming. Right when you start, you don't always see that, but you're growing, you're building, and then it's like, oh, now I have to rebrand everything and come up with a new name because I never trademarked this. So that's my spiel on trademarks. We've got 3 minutes. I'm happy to answer any other questions. Lizzie, what do we got?
Yeah, so this question came in from Erica. She goes, how about asking our teachers to be vaccinated? Can we make that a prerequisite even though they are independent contractors?
Okay, so the big distinction here is between contractors and employees. With a contractor, it would be very, very difficult to be able to enforce that. The idea being that a contractor has complete control over the way they provide the services. But also what you could say to a contractor is, we will only be working with people who are vaccinated. And then in that case, right, and all of it's about, remember, coming back to the chronology of the agreement, like presenting them with a contractor agreement that says something about vaccinations, then they sign it, and then enforcing the rights. If you've been working with someone and you have an existing contractor agreement, it'll be tricky to sort of be like, oh, and by the way, you need to be vaccinated tomorrow or we can't work with you. In that case, you need to reasonably address it. And then with employees, you can mandate that anyone who works for you is vaccinated, citing a public health concern. You want to make sure that everyone who you're doing this with has had, the opportunity to be vaccinated. And yeah, and then you just have to let them know like what happened. You have to give them a time period to make the transition. And then if they decide not to, you're allowed to say like, this is a requirement that we have in order for you to work with us in our studio.
Got it. So another question came in about the legal end of using music we don't own the rights to. Actually, Conscious Counsel wrote a blog specifically about this. So I will share that in the post-webinar email with you, Scott. But we won't use our time to answer that question. Oh, thanks, Jake. Always in there. So Jake added that link. Going back to waivers, this is another question. So does this mean when you add something like Yoga Nidra or Yin Yoga or something like that and start implementing it in your teaching? Elena asked, do we have to pay someone to update our waiver, or is this something that yoga instructors can do on their own?
It depends. For example, at Conscious Counsel, if our clients have purchased a waiver and then they want to make modifications to it down the line, we always include that in the original price. If you work with other lawyers, I can't speak about what that's like just because I don't know. But the important thing to know is that Yin and Nidra are probably like the two most chilled out versions, but you do want to update your waiver for all of the different types of yoga. So if you weren't doing acro yoga, now you're starting to teach acro yoga, you definitely want to make sure that the waiver addresses that.